Good day, everyone, and welcome to this very special session. A special welcome, of course, to this esteemed group of patron Chief Justices of the Commonwealth Judicial Education Institute. The truth is that without you, the Institute would not be able to function as it does. And on behalf of the Institute, we say thank you for your support over the years, and we look forward to your continuing support. Today's presentation is about a call for action, the critical role of judicial officers in the eradication of contemporary forms of slavery. I am Peter Jamadar, a judge at the Caribbean Court of Justice. I'm also the Vice President responsible for programming of the Commonwealth Judicial Education Institute. To put this presentation in context, a little bit about me and about where I come from. I was born in Trinidad, which actually was an early Spanish and then British Caribbean colony. I have lived and worked in the Caribbean for most of my life. You may not know, but these lands are the ancestral lands of mainly two Amerindian First Peoples, the Arawakans and the Caribans. And archaeological research has yielded human artifacts and presence dating as far back as 5000 BCE. I therefore want to start this session by acknowledging these First Peoples and their lands, and also to pause, to affirm with remorse that they were also among some of the first victims of post-colonial slavery, forced labor, and exploitation. Most of us should know, I hope, that the Atlantic slave trade began in the mid-1660s. What did it involve? It involved the forced taking, transportation, and exploitation of human labor. However, in 1807, the British government declared the transatlantic slave trade, I should say the African transatlantic slave trade, illegal. Legal emancipation did not happen until 1834. However, even with emancipation, and due to the consequential labor shortages on the plantations, legally emancipated Africans became sources of what was known and is known as indentured labor. What was a feature of indentured labor? Contract-bound labor, usually enforceable by criminal sanction. However, from 1837, indentured laborers came mainly from India and China to these shores. They were the sources of cheap and forced human labor in Caribbean colonial territories. As a matter of fact, the British Indian indentureship continued until the 1920s. And so these Caribbean events are significant for us in this region, but they were not limited either to British colonies nor to the Caribbean. This was a feature of European colonialism. It is important that I say that these perverse ideologies were supported by legal systems operating under an unshackled, capitalist-driven rule by law, supported by immoral and systemic, that is to say, institutionalized, patriarchal, racist, and classist cultures, and supported by systemic othering, objectification, and commodification of human beings. Why is this important? This is important because it is these features that have continued into this time, which we will explore in greater detail as we go along. The point is, for the moment, set in context, is that in Caribbean spaces, these historical practices of what I will call overt chattel slavery, human trafficking and forced labor, these are woven into the fabric, cultures, and psyches of our people. The trauma, injustice, and inhumanity of these experiences and their consequences resonate, reverberate, and persist. Indeed. And this is why we are gathered here today and for this presentation. These very practices, morphed into new forms to suit modern perversions, are globally rampant and increasingly so a cause for concern. Hence, a call to action, the critical role of judicial officers in the eradication of contemporary forms of slavery. Assisting me today is Larissa Pena. Larissa is a judicial counsel with the Caribbean Court of Justice and works with me. She is also the executive administrator of the Caribbean Association of Judicial Officers. And Larissa has a special interest in this subject. It is a matter for which she has, in her own professional career, worked with in Trinidad and Tobago. But more of that later. For now, Larissa.
Thank you, Judge. Good day, everyone. It's a pleasure to be a part of this presentation. Did you know that the Commonwealth is made up of 54 member countries? And as we continue this presentation, I just wanted to share with you some what I thought was alarming figures. 1 in 150 persons in the Commonwealth is living in contemporary forms of slavery, such as forced labor, trafficking, or other exploitative conditions. Did you know that only 24 Commonwealth countries have laws that recognize that victims of human trafficking or exploitation should not be prosecuted or punished for crimes that they may have committed under coercion? And only 31 Commonwealth countries have actually criminalized commercial child sexual exploitation. An estimated 40% of the 40.3 million people living in modern slavery reside in Commonwealth countries. This represents about 15.7 million men, women, and children in forced labor, forced marriage, and human trafficking. 1 in every 130 women and girls globally is currently trapped in modern slavery. An estimated 29 million women and girls are victims of modern slavery.
Yeah, these are truly alarming facts, Larissa.
They are.
And in a sense, they set the context for our presentation today and the journey that we're about to embark on. Once again, thank you for being present and welcome. So let's begin the journey with this introduction, after this introduction, which we hope would have piqued your interest and engaged your attention. Eradicating modern slavery. Well, in a sense, we've heard this. 1 in 150 people in the Commonwealth live in modern slavery. That's a remarkable statistic. But it is not a statistic from the 1700s, for those of you who thought the idea of slavery was some archaic thing of the past. No. This information is taken from the 2018 Global Slavery Index, which is the world's leading data set on measuring and understanding slavery. Alarmingly, and I hope you Patron Chief Justices note this, slavery exists in each of the 54 countries that make up the Commonwealth, and it is deeply embedded in transnational supply chains. How much has really changed is what we invite you to consider. And we invite you to begin to reflect on the enormity of the problem and the currency of this issue. Eradicating modern slavery. Well, in 2018, heads of government met and states committed to try and achieve effective measures to eradicate forced labor, end modern slavery and human trafficking, secure the prohibition and elimination of the worst form of child labor in all forms by 2025. But this is 2021. The stark reality is, as of 2020, very little has changed following the commitment made by the Commonwealth heads of government in 2018. And this comes from an executive summary and a 2020 report on the eradication of modern slavery. Larissa.
Judge, this is a very important topic, and I would like to shine some light on women and girls as a vulnerable group. As we stated earlier, 1 in 130 women and girls globally is living in modern slavery. And this is a very pressing topic, as women's rights are an essential part of the overall human rights agenda. And we're trained on the equal dignity and ability to live in freedom all people should enjoy. This is a quote from Justice Ruth Bader Ginsburg from the Supreme Court of Justice of USA. Some further figures as it relates to women and girls. 99% of all victims of forced sexual exploitation are women and girls. 84% of all forced marriage victims are women and girls. 58% of all forced labor victims are women and girls. And 41% of all state-imposed forced labor victims are women and girls. And these figures are taken from a Walk Free 2020 report. So these figures are current as of 2020.
Thank you very much, Larissa. I mean, the thing is that we speak a lot about gender equality. We speak a lot about trying to have respect for the dignity of women and children. And yet still these statistics are current statistics. And the question for us as heads of judiciaries and as senior judicial officers is, what role or roles do we have to play? What role or roles should we be playing? Let me tell you two stories. They're historical for the moment, and so let's begin. I told you a little bit about this story already. The story of the Atlantic slave trade from the mid-1660s, which involved, as I told you, the forced taking, transportation, and exploitation of human labor. Well, moving further along in this little story, as I also shared with you, was the use of indentureship, of the indentured labor system, to perpetuate what in fact was then a form of forced labor and the exploitation of humans. Humans who were commodified, humans were used basically in what would now be called human trafficking, humans who were exploited, humans who were considered as other, humans who were considered as commodities, as chattels. That's then. And you may say to yourselves, well, what has changed? Well, for your information, in 1926, the Slavery Convention was agreed to by several Western democracies. It happened in the League of Nations, and it was intended to be the international foundation for preventing and suppressing the human slave trade. In the preamble to the convention, I've highlighted there on the screen, you can see it, one of the clauses. Why? Because it says that considering moreover that it is necessary, that is to say, the eradication of slavery is necessary, to prevent, and I want to focus on these words, forced labor from developing into conditions analogous to slavery. So as early as 1926, there was this recognition that chattel slavery was not just the problem. It was not just a question of chattel slavery. It was at heart forced labor that was the problem. And so keep that in mind, please, as we move forward. Because in the Convention on Slavery, Article 1 defines slavery. It's important for us because in the contemporary world, we do need to critique this to a certain degree. Notice the language. Slavery is a status or condition of a person over whom any or all the powers attaching to the right of ownership are exercised. Well, that is the language of contract, right of ownership. But I want to suggest that if you view this through modern constitutional lenses, especially in post-colonial contexts, we need to critically interrogate this language of contract in the context of human trafficking, forced labor, and contemporary forms of slavery. What we really have to do as lawyers and as judicial officers is unshackle. We have to unshackle both the history and what I call tabulated legalisms around the construction of what is slavery, around the interpretation of what is slavery in our times. So if we were to move along, that's a bit of the past. What about our stories? What about our stories in this contemporary time? Well, let me tell you a little story. In October 2006, a young woman, MM, was brought into the UK from an African country and entered into a contract of employment. Between 2006 and 2010, she, MM, was made to work long hours, in many instances up to 24 hours a day. She was underfed, hardly paid, not allowed to leave her host premises on her own, had little contact with her family in Africa, and even then her conversations were monitored, listened to, and recorded. Well, the matters reached the courts, and the question is, what happened next? Well, it reaches the court in the form of R versus SK. And in the Court of Appeal, these quotations that you are seeing on your screens, I think, are helpful for us today. The essence of the concept of slavery is treating someone as belonging to oneself by exercising some power over that person as one might over an animal or an object. Now, you can see in that resonances still of the language of contract. Moving along, however, we see a little development. Nor should the concept be seen as archaic. Well, clearly not. It is not reminiscent of an era remote from contemporary life in the United Kingdom. No, it's a modern phenomenon. In the modern world, exploitation can and does take place in many different forms. Perhaps the most obvious is where a human being is treated by another as an object under their control for sexual purposes. So here's the Court of Appeal saying, look, well, hold on a minute. The essence is this idea of exercising control as if somebody were an object that you had power over. But they're going a little further. They're saying, but wait a minute. Wherever you treat a human as a being as an object, that's kind of the essence. And then at the end, a final quote, where forced or compulsory labor is concerned, it can be direct. It can also be indirect. Now, I just want to pause there. Because, of course, the chattel slavery that we have looked at historically was very direct. But here now the Court of Appeal is recognizing that forced or compulsory labor can be indirect. I'm going to quote now from the Court of Appeal. Constraint can be mental or physical. It can be imposed by force of circumstances. And that becomes the entry point for what we really want to talk about. Because we really need to sort of move away from this idea that we have, that slavery is something that is physical. No, it can be psychological, it can be emotional, it can be financial, it can be emotional, it can have all of those elements, as we will soon discover. So where do we go from here? Well, before we move forward too much more, I just want to anchor all of this in Article 1 of the Universal Declaration of Human Rights. Of course, passed after the Second World War, all of the atrocities of the Second World War, in 1948. And what is the essence? All human beings are born free and equal, in dignity and in rights. That's the baseline. For us as judicial officers, this has to be the baseline. The baseline for how we treat people in our courts, for how we treat each other. But when it comes to the people who appear before us in court, we have to understand that the fundamental principle is all human beings are born free and equal. Of course, that makes it very plain that any kind of forced labor, any kind of constraint, any kind of exploitation, human trafficking, slavery, forced labor, all of that is contrary to Article 1. But it also, Article 1 also, as I'm going to hope to demonstrate, or we are going to hope to demonstrate today, also creates for us duties and responsibilities in relation to the people who come before courts, and in particular, the criminal courts. Larissa.
Thank you, Judge. So even though local laws don't always recognize the eradication and the importance of eradication of modern slavery, the international community has recognized these important principles. So some international anti-slavery laws are the 1926 Slavery Convention of the League of Nations, and this is the predecessor to the United Nations. The 1948 Declaration of Human Rights. I know, Judge, you quoted Article 1, but there's another article that says, no one shall be held in slavery or servitude. Slavery and the slave trade shall be prohibited in all of their forms. We also have the 1956 Supplementary Convention on the Abolition of Slavery, the Slave Trade, and Institutions and Practices similar to slavery. And this convention banned institutions and practices similar to slavery, such as debt bondage, serfdom, servile marriage, and these are just a few of the anti-slavery laws that they have today.
Yeah. Thank you very much, Larissa. But what strikes me in this, Larissa, is the focus here, even as early as 1956, on institutions and practices similar to slavery.
Yes.
Yeah. So already by 1956 is a recognition, would you say, that it's not just this more ancient idea of, shackles on. Mm-hmm. It's something much more subtle than that.
Yes, yeah? Judge, and very indirect as well.
And exactly, and that indirect, exactly. Well, how widespread is this, Larissa?
Well, as you can see, this is an international issue that affects the world. As you can see, this is a world map of modern slavery. As of 2018, you can see that it affects all of the countries, some more than others.
Yeah, I really think that this map is impactful.
Yes.
Because when I first saw this map, it shocked me. Mm-hmm. To think that in 2021, well, I mean, this is 2018, mm-hmm. but as we heard earlier, it hasn't changed very much.
No.
That this is the world we live in. And so, Chief Justices, what we really want to do is invite you to just allow this map, which is going to come back up on your screens right now, to just seep into your consciousness. And just recognize that we as judicial officers, as you as heads of judiciary, this is the world that we are living in today. Let's move along a little bit and move along to some maybe a little more theoretical aspects of the matter. What is slavery in our times? Well, we've already started, Larissa and I, to tease that out for you a little bit, and I think you should be getting a sense of where we're going. What are the values and principles that should inform a contemporary reimagining of the normative legal standards that should adjudicate its occurrences? It's a matter directly for us as judicial officers, and I say with respect, especially for you as heads of judiciary, chief justices. Well, Professor of Human Rights and Equality Law at Queen's University in Belfast, writing on the topic slavery and the constitutional role of judges in 2011, observes that the modern view of slavery takes the idea of legal ownership and views it as wrong. All right, no problem. Why? Because of the deeper meaning that it has. And this is the focus that Larissa and I want to bring to bear today. That it reduces humans to mere objects and is thus fundamentally inconsistent with their humanity. And what we hope will resonate with you when you hear this is Article 1 that we've just looked at of the Universal Declaration of Human Rights. The deeper meaning is that it reduces humans to objects, the objectification, the commodification, and is thus fundamentally inconsistent with who they are. That is to say, born free and equal in rights. What we therefore want to present today is what we call a rights-centric approach to the matter. In a right-centric approach, there are 4 limbs: sovereignty, supremacy, rule of law and human rights, and judges as guardians of constitutional values. These are seminal provisions. In Caribbean spheres, where we have written constitutions, states and constitution are considered sovereign and supreme. State is sovereign and the constitution is supreme. And all of the constitutions in the Anglo-Caribbean jurisdictions that have written constitutions are premised on the rule of law and have entrenched human rights, fundamental human rights provisions. This idea of supremacy suggests that these 2 principles of the rule of law and of human rights, these are so fundamental that all other laws must become subject to them. And that is what the supremacy principle introduces. But in addition, these constitutions recognize, and the case law in the Caribbean has developed this very well, that judges are guardians of constitutional values. So for us, what does that mean, especially for us in the Caribbean? But first, a little bit about some of the cases for those of you who want to look them up. As far back as 1967 in Collymore versus the Attorney General, a case from Trinidad and Tobago, these explorations began. And then more recently, at the Caribbean Court of Justice, the apex court for the region, in Nerve versus the Queen, in Macauan versus the Attorney General of Guyana, in Belize International versus the Attorney General of Belize, and Marin versus the Queen, the CCJ has consistently insisted not only that judges are guardians of constitutional values, but that the rule of law, not rule by law, the rule of law is a significant and salient governing principle. Now, I draw a distinction, one that you are all familiar with as jurists, between the rule by law and rule of law. Because as you know, slavery was legal, but it was ruled by law. The rule of law incorporates human rights values, and from that lens, that is to say the lens of rule of law, slavery is clearly something that is unacceptable and inconsistent with these rights. Well, what does the judiciary, as an arm of the state, have a duty to do in the face of contemporary forms of slavery? Is it enough for the judiciary to sit back and say that's a matter for Parliament and the executive? Or does the judiciary, and do we as judicial officers have a responsibility to pay keen attention to what's happening before us in our courts to discover whether or not there are abuses of human rights through the form of human trafficking, forced labor, and other contemporary forms of slavery? I am suggesting that because of these principles of sovereignty, supremacy, the rule of law, and the judges as guardians of constitutional values, judicial officers have a constitutional imperative to act. Sitting on our hands, turning a blind eye, or even getting bogged down in legalisms may simply not be options for us when we are faced with contemporary forms of slavery and when we view them through these four lenses. We suggest, therefore, that there are 9 imperatives, or you may think of it as practical implications of this obligation of judicial officers. These are situational awareness, intersectionality, the use of the non-punishment principle, procedural fairness, avoiding secondary victimization, alignment with international law and practice, post-colonial approaches to the interpretation and development of law, mindful judging, and judicial humility, compassion, and concern. And what we want to do as we move along is, bearing these in mind, to begin to explore each. We don't have a lot of time today. Each just in a sort of general sense, so that you can get a flavor of what these mean. Let's begin first with situational awareness and intersectionality. The case of RVL. Well, this case reaches the Court of Appeal in the United Kingdom in 2014. Here's a young person prosecuted for the cultivation of cannabis on a cannabis farm in the UK. That's our context, factual matrix, as we say. Convicted, the matter reaches the Court of Appeal. The Court of Appeal recognizes that this young person was a victim, survivor of human trafficking and forced labor. And does what? Quashes the conviction. Notice, therefore, the situational awareness. The recognition, understanding, and awareness that a matter may present itself as straightforward, cultivating cannabis on a cannabis farm. If you stay in that silo, well, then he's guilty, as happened at the lower courts. When in reality, though that is how it may present in reality, if you have situational awareness, it involves intersecting and other influencing considerations. And that's what the Court of Appeal got. And so the Court of Appeal, recognizing these two elements of situational awareness and intersectionality, that is to say, the intersectionality of the crime of cultivating cannabis with the reality of human trafficking and forced labor, quashed the conviction. Therefore, as judicial officers, we need to develop knowledge and awareness of certain key indicators: living conditions, debt, bondage, ethnic, cultural, linguistic impediments, all the kinds of things that are like red flags that we need to become aware of, that may help us look a little bit deeper and further to discover that what presents as a crime, the cultivation of cannabis, actually has something much more going on, as we would say, behind the scenes, behind the curtains. And so if we as judicial officers have a closed-minded kind of approach, and we want to stay within the four corners of the case before us, what we can miss is the existence and impact of contemporary forms of slavery in these kinds of cases. Now, I pause because many of you have come up through the ranks. You may have sat in criminal courts, adjudicating criminal matters, maybe trafficking matters, maybe matters involving immigration, maybe matters of a like nature. Do you think that any of the people who came before you could have been victims, survivors of human trafficking and forced labor? What about women charged for prostitution? You remember we heard earlier that the most prevalent form of this, or a very prevalent form of this, is sexual exploitation. How did you treat those cases? Could some of these persons have been victims, survivors of forced labor, human trafficking? And if so, did we miss them? And if we did, is it enough to us to say, well, this was the matter before me and I decided it? No, well, what about the constitutional imperative? What about Article 1 of the Universal Declaration of Human Rights? What is our duty? To move along a little bit as we continue to journey through these principles. The first is, the second I should say, but actually this is the third. The third is the non-punishment principle. And what does this mean? Again, from RNL, Court of Appeal of the UK, the culpability of any victim of trafficking may be significantly diminished, and in some cases effectively extinguished, not just because of age, but because no realistic alternative was available to the exploited victim survivor but to comply with the dominant force of another individual or group of individuals. So right away you see what is happening here. The law is evolving to achieve justice in this context. And so that where the law discovers that a person appearing before the courts may or is a victim of human trafficking, let's say, or forced labor, there can be a consequence in terms of sanction. Sanctions can be diminished or effectively extinguished. And this is something that we, certainly in the Caribbean, but I get a sense even in the wider Commonwealth, this is something that we are not as aware of as we should be, and maybe not as actively engaging as we need to be. Therefore, care needs to be taken, I accept, and a right balance must be struck between the public policy need to convict criminals, absolutely. But that has to be balanced in the context of our conversation today between shielding individuals from re-victimization. Going a little bit deeper into the non-punishment principle, and in a sense I've already started to build this out. Individuals should not bear criminal responsibility for acts they were forced to commit while under the control of others and subject to force, threats, deceptions, or other compulsions. Can you accept that? Would you agree with that? Would you be willing to be proactive enough to execute that in the exercise of your judicial function? For your information, this principle has been adopted by the Council of Europe Convention on Action Against Trafficking and Human Beings in 2005. Notice that it is a negative right requiring state restraint. What do I mean by that? What I mean is, if it is that the punishment principle applies, then it means from the level of investigation where you may discover that these are victim survivors of human trafficking, forced labor, at that level of prosecution, a question arises: should they be prosecuted? That is the state exercising restraint not to prosecute. Then the matter may reach before the courts, and it comes to the attention of a judicial officer. Should the judicial officer, or should the state acting through the agency of the judiciary, exercise state restraint and not allow a prosecution to continue? And then, at the back end of a case, suppose there is a conviction or it is on appeal, should the state reduce or quash, again, exercising restraint in the non-imposition of what may be ordinarily the sentence due for an offense. So I'm going to come now to a slightly different approach, but for now, this is what I want you to think of as state restraint. However, certainly in the Caribbean, where we have the constitutional values that I spoke about, the non-punishment principle, I suggest, creates a positive obligation to actively and adequately investigate and eradicate all forms of forced labor and slavery. So I'm shifting and inviting you to walk along this path of a shift from state restraint to a positive constitutional obligation to investigate and eradicate. Why? It's founded upon the freedom, dignity, and equality of all persons. It is founded upon liberty, non-discrimination, and protection of the law principles. Caribbean constitutions have specific provisions speaking to the protection from torture and speaking about cruel and inhuman or degrading punishment and saying that those are inviolable. And that is to say, these are fundamental things that are not permissible. In 3 jurisdictions in the Caribbean, Barbados, Guyana, and Belize, there are specific provisions in the Constitution speaking to the protection from slavery, servitude, and forced labor. And so that certainly where you have written constitutions with these kinds of provisions, these are values which I am suggesting, grounded in the rule of law and in fundamental rights, create a positive obligation. Because if, for example, in Barbados, Guyana, and Belize, slavery, servitude, and forced labor are unconstitutional, and the Constitution is supreme, then is it enough for judges to sit back and say, well, nobody told me about that? Or do we have a duty to become situationally aware, to look for intersectionality proactively in order to protect those who are the victims, survivors of slavery, servitude, and forced labor? I'm not going to dwell more on it, but I'm going to leave one last thought on it for you. You know, we speak about a hierarchy of rights. And in this hierarchy of rights, there is this idea that no fundamental right is absolute. Well, that may be true in theory. Let's use a kind of an easy example, access to the courts. Suppose the state were to pass a law saying a certain class or group of people were not to have access to the courts. Is access to the courts, where is access to the courts on the range of rights? Absolute, almost absolute. What about slavery? Where is slavery on this range of rights, hierarchy of rights? I invite you to think about whether or not you can conjure up some sort of justification for slavery. And if you can't, then whether or not the notion of slavery could be so fundamental that its prohibition reaches a standard of being absolute. Why is this important? It's important because if these kinds of conduct reach that standard of prohibition, that is to say, moving towards absoluteness, then what is the responsibility of you as heads of judiciary? What is your responsibility as Commonwealth Chief Justices? What is your responsibility for educating your judicial officers, for ensuring that the people who come through your courts are not being denied the protection that the constitutions say they are entitled to, and therefore being re-victimized or punished when they ought not to be. These are not matters of yesteryear or yesterday. They are matters of today, and they will be matters for tomorrow. All right, so let's move along a little bit. As we go along, let us move along and try and cover some other areas. We'll go a little more quickly as we proceed. But procedural fairness. Everyone who comes before our courts should be the beneficiaries of procedural fairness, but especially those who may be victims of slavery, human trafficking, and exploitation. Voice, respect, understanding, trust, inclusivity. Do we facilitate voice? Do we engender respect? Are we sure that people understand what is happening in our court? Do they trust us? Are they included? One of the things that has come out in the research in this area of contemporary forms of human trafficking is that victim survivors, when they come into the court system, the formal court system, first of all, they feel very voiceless. Because of the whole hierarchy and the system is new, they're often maybe migrant, maybe don't speak the language, etc., etc. Plus, they've also come, you remember, in a context of coercion, maybe there are immigration issues, so there's a lot of fear. Are we facilitating voice? How do we regard them? Do we make sure they understand? And very, very critically, they lack trust. They do not trust the system. They don't trust authorities. Why? Because they are afraid they're going to be packed up and sent back, or imprisoned, or exploited. That has been their experience. They don't feel a part of, welcomed. And so these elements of procedural fairness are very important. At the CCJ again in 2020, in the case of Pompey and the DPP, the court was at great pains, albeit post-conviction, to talk about giving the victim a voice, and in so doing, recognizing the inherent dignity and value of a victim's personhood. And so the idea of embracing victim impact statements. At that stage of proceedings, the CCJ has suggested is something in the appropriate circumstances that should be encouraged. Secondary victimization. Well, this, in a sense, is a matter that is self-evident. Judicial officers must be careful to avoid secondary victimization. So measures must be put in place to make sure that the risks to victims are reduced, eliminated. We spoke about the stress and trauma of victims who are victims of human trafficking, the court's responsibility to take steps to manage this trauma and stress. But even the types of questions put to these victim survivors. Judicial officers, as judicial officers, we have a responsibility to make sure that re-victimization, secondary victimization is not happening by the questions that are put that may be dehumanizing or disrespectful or eroding dignity. Who manages this? What we are suggesting is that judicial officers, certainly in Caribbean spheres, but I suggest wherever there are written constitutions that have tried to demonstrate, have a positive obligation, responsibility, and duty to take steps to avoid secondary victimization. Alignment with international law. Is another area that we want to touch on. Modern slavery, of course, is a multifaceted cross-border global phenomenon. I think that much is self-evident. And therefore, judicial officers need to situate themselves in the context of their roles in a global community. It's not enough to be sitting in a small court, in a jurisdiction, or in a district. Judicial officers, therefore, need to become aware of state treaties and how the content of their state obligations may impact proceedings before them. Why is this important? Well, again, the Caribbean Court of Justice, in a series of cases, the Attorney General versus Joseph and Boyce, the Maya Leaders Alliance case, and in McCowan and others versus the Attorney General of Guyana, has been at pains to say that the approach to be taken to the interpretation and application of law must ensure, so far as is reasonable, that these approaches align with state international treaty obligations. Now, this is not trying to convert a dualist system into a monist system. It is not trying to incorporate directly what are international law treaties and provisions into domestic law. No, in a dualist system, as exists in a lot of the common law world, unless there is the passage of local legislation, then we all accept that these principles are not the law of Trinidad. But what the CCJ has been doing is to say, that may be so. But that does not mean that in the interpretation and application of local law, that these international principles and values that your state has signed up to, has said to the world, we agree to and we subscribe to, has represented that not only internationally, but also through its signature of these treaties, represented that clearly to its own people. And so judicial officers, in this global context of modern slavery, they have a duty to not only know and become aware of what these state treaties may be, but to begin to think through these lenses and approach their work through these lenses. I'm suggesting that this approach is even more pressing in cases of contemporary forms of slavery because of the multifaceted and interterritorial, even intercontinental nature of the phenomenon. Post-colonial approaches to the interpretation and development of the law. Well, why is this relevant? It's relevant because, as we have looked at, certainly in post-colonial times, it is colonial legal structures, colonial attitudes, colonial values that legitimized the transatlantic slavery in relation to Africans. Chattel slavery, indentureship in relation to Indians and Chinese. I'm speaking mainly about this part of the world, what we call the Caribbean sphere. And so when we come to read and interpret law, we cannot pretend that the precedents that exist were not shaped and formed by a colonial mindset. And it's an interesting thing about law, that precedent in the common law world dictates what the law should be or is. And in a funny way, the past is leading the future. But what do we do when the past was responsible for the atrocity? How do we view those laws, those understandings, those methods of interrogation that were actually interwoven into the very problem that we are trying to address? And so what I want to put up on the screen for us to have a look at now and to consider is what we call post-colonial approaches to the interpretation and development of the law. In Marin versus the Queen, a 2021 decision of the Caribbean Court of Justice, this is looked at. And I want to suggest that colonial understandings of slavery and legal principles developed in relation to it need to be carefully and rigorously scrutinized. That contemporary judicial officers need to be acutely aware of these precedential limitations. And judicial officers need to be independent and creative enough to ensure the development and use of appropriate procedural and substantive approaches to cases in which elements of modern slavery are present. For your information, and I won't dwell on it, just a quote from Marin. In Marin, the CCJ said this: applying a consciously anti-colonial interrogative approach to analysis is part of this developmental approach. It is an approach that considers a law's colonial antecedents and purposes and asks whether in light of these it is still constitutionally various and legitimate. Framed in a positive way, I'm still quoting from the court, it is an approach that encompasses an independent and post-colonial developmental ideology and hermeneutic to Caribbean constitutionalism. One that recognizes that law and legal structures are historically contingent. So, again, this is just but a conversation that we're having, and you as heads of judiciary, I'm inviting you to think about these things. Because if you are persuaded about these things, then a further obligation may arise. What do you do? Do you need to then embark on educational programs in terms of your judiciary's so-called higher and lower? But let's keep moving. Mindful judging. Mindful judging is an approach that says that as a judicial officer, you need to have a 360-degree view of court proceedings and court relationships. Mindful judging gives rise to enhanced degrees of courtroom consciousness that may otherwise be overlooked on account of familiarity. In other words, when we sit in a court, we can become so habituated to the routine of what we do. So we're sitting in a drug court, and every day, drug trafficking cases. We actually become mindless. Mindless in the sense that we are not acutely awake and aware of what's happening. So you remember earlier we spoke about situational awareness and intersectionality. In fact, it took the Court of Appeal in the UK to have that degree of situational awareness and of intersectionality to recognize that the young person who was convicted of cultivating cannabis on a cannabis farm, in fact, was a victim survivor of human trafficking and forced labor. And so, mindful judging means that you have to be alert, aware, curious about what's happening. Alert to what are the signs and signals, the red flags. You have to also, as we're going to come to now, do something even more. You have to also, I am suggesting, have judicial humility, compassion, and concern. In the context in which we are speaking, judicial humility is a necessity. Let me say that again. In the context of contemporary forms of slavery, judicial humility is a necessity. Why? It is an antidote. This is very important for us, judicial officers. To the hubris that judicial officers can be prone to develop following appointment. You know what we call it? Judicial arrogance. It creates a limiting and closed-minded approach. that's why it's a problem in this context. I'm not talking about confidence, you know. I'm talking about that approach that thinks I am right and I am right. And the way I see things is the way they are. It is forgetting, in fact, that the way we see things is really the way we are, and often not the way things are. But humility overcomes that hubris that we judicial officers can so easily succumb to, and it opens us up to be more open-minded, open-hearted. Compassion. What do I mean by compassion? Well, judicial compassion is not some sort of warm and fuzzy feeling. It is rather a rational, jurisprudential, cultural, and societally sensitive approach to the well-being of people and law as they intersect. And right away with that definition, I hope you can begin to see how it can become relevant. Because when we are culturally and societally sensitive to the well-being of people and the law, we can therefore recognize that the non-punishment principle has a role, that re-victimization is a matter that undermines the administration of justice and the rule of law. And so, as we move forward in this journey today, I want to invite you to consider these 9 principles that we have rehearsed, and not least of which being this 9th principle of judicial humility, compassion, and concern. Well, where are we? Culture. A real challenge for us in the context of this issue is the challenge of culture. I remember when I first did a talk on this matter, a question was raised about what if the culture supports the use of women and children for labor? But let's look at an example. Kurau versus the state of Niger. In 1996, age 12, Miss Kurau was sold for a sum of money in the context of wahia. That was a practice obtaining in the Republic of Niger, which consisted of acquiring a young girl, generally under conditions of servitude, for her to serve both as domestic servant and concubine. Now, just let's put this in context. Wahia is a practice, a cultural practice. The person to whom she was sold, usually an older male, was known as her master. So for about 9 years, Miss Kurau served in the house of her master, carrying out all sorts of domestic duties and serving as a concubine. She had to endure forced sex and was a victim of repeated acts of violence. In 2005, Miss Kurau was actually issued a certificate of emancipation. Because remember, this is a contractual thing, eh? But her master refused to let her leave. So in 2006, Ms. Kurau commenced court proceedings seeking her freedom. Again, this is about culture. This is a practice that was prevalent, or being practiced at least, in the state of Niger. In 2008, her case reached the Community Court of Justice for the Economic Community of West African States. And that court held that she was a victim of slavery for the 9 years that she was held by her master. That court held that the state of Niger was liable for its failure to deal adequately with this form of slavery and awarded her about 20,000 US. Now it's important for me to say this. The state of Niger's argument was that she was not a slave, that she had lived, and I quote here now, more or less in a happily marital relationship with the master. So you see what's happening in this case. The state had a positive obligation to do something about the practice, and its failure in the context of this particular case resulted in this approach by the community court and the denouncement of the state's approach. What did the court have to say? I think this is an important point as we come closer to the end of this session. And I quote, "Even with the provision of square meals, adequate clothing, and comfortable shelter, a slave still remains a slave if they are illegally deprived of their freedom through force or constraint. All evidence of ill treatment may be erased, hunger may be forgotten, as well as beatings and other acts of cruelty, but the acknowledged fact of slavery remains." That is to say, forced labor. So you see where we reached? Forced labor. The idea of ownership has shifted a little bit. There is nothing like goodwill slavery, even when tempered with humane treatment. Involuntary servitude is still slavery. So, what do we take away? Forced labor or involuntary servitude are the hallmarks of contemporary forms of slavery. The court went further to say, the moral element in reducing a person to slavery resides in the intention. Now look at where they've located it, in the intention to exercise control over an applicant, in this case Ms. Kurawu, even after the document of emancipation had been made, and so therefore there was no doubt. The point being, and I think this case is interesting for this reason, that the 1926 colonial concept of right of ownership as central to the notion of slavery has now been, in a way, interrogated. And the more modern approach is to look at forced labor issues and involuntary servitude as definitive of contemporary forms of slavery. And so notice the shift in focus, and the focus on intent, less on form. I quote, "The moral element in reducing a person to slavery resides in the intention of a person exercising the power and control over another." And so, I think, in a sense, for today's session, we are beginning to come full circle. We are beginning to reach that point where we have seen our responsibilities, and we have seen, from a legal point of view, what this phenomenon actually is. And that is to say, it's about forced labor, involuntary servitude. And very importantly, no amount of good treatment is exculpatory in this area. What then do we make of the role of judicial officers?
Judge, you've shed a lot of light on the role of judicial officers today. And I think at this point, it's important to all pause and reflect a little bit on this topic. One question that comes to mind is, would you be surprised, shocked, and disturbed to discover that you may have sent persons to prison who are victims or survivors of human trafficking and forced labor? A suggestion. What is required is not merely a technical, legal knowledge of an area, but what is required is a cultural change in understanding the phenomenon of modern slavery. So this is a call to action for the victims and survivors of modern slavery. How do we protect victims and survivors? How do we raise awareness? Do we need more sensitization, education, and training initiatives? Again, we need to bear in mind the hidden nature of human trafficking, that it may not always be direct, that slavery could be indirect, and we also need to bear in mind the reluctance of many victims, survivors, to reveal their circumstances. And this may be because of trauma, fear, shame. So a takeaway for me was this whole topic has really opened a Pandora's box, changed my paradigm. In private practice, I represented immigrants, and very often you would see the immigrants had criminal matters going side by side. And in this light, it makes me think of R&L, the case of R&L, because it's groundbreaking. It shows you that it highlights the issue of the non-punishment principle. And I think it really shifts our mindset away from, tabulated legalism into, the broader perspective of protecting human rights and eradicating modern slavery. And on that note, I really would like to thank Justice Jamadar for letting me be part of this presentation, for exposing me to this area, as I think it really is an important topic, and it was a wonderful experience. Thank you, Judge.
Yeah, no, but and thank you, Larissa. Because the truth of the matter is that Larissa has been very instrumental in assisting in the preparation, the research of what we are presenting to you. And, for many of us, especially for many of you Patron Chief Justices, our careers have been long, and we may be coming closer to the end of our careers. I'm not saying that you are close to the end, but you may be coming closer. But it is for the younger attorneys and advocates for whom this matter is going to become, I think, very real. Of course, that doesn't mean that we must not take steps right away. And so, for my part, what I want to invite us to think about is, as we move to stop human trafficking, I think it's very much for us, especially for you, heads of judiciary, a call to action. There is much to think about. There is much to be done. We are the ones called to think and to do. We have the tools. Are we up to the task? Well, for thousands of innocent and vulnerable lives, for hundreds of communities and families, we are their only hope. What I want to say, therefore, as we come to the close, is to say thank you for the opportunity to share with you my thoughts on this very, very important matter. Having gotten involved in this, it has changed me as a judicial officer. I reflect on, because this is my almost 26th year as a judicial officer at the High Court, in the Court of Appeal of Trinidad and Tobago, and now in the CCJ. And I wish I had this information when I started. I really do. I'm not going to say that I look back with regret, because we cannot change the past. But what we can do is change the future. And so it's for me, instead of looking back and spending time looking over my shoulder at what may have been or could have been, I prefer to look forward. And so for me to be here and to have this opportunity is for me to play a part, I hope, through persuading you, Patron Chief Justices, that this is a matter that calls us to action. Action that we must take, and that we must take it now. So I want to just repeat my gratitude to you for being present, all of you patron Chief Justices from the Commonwealth for your support of the Commonwealth Judicial Education Institute. And in addition, I want to offer some acknowledgements to Sandra Oxner, who is the founding president of the Commonwealth Judicial Education Institute, to Sneh Aurora, director of the London office of the Commonwealth Human Rights Initiative, to Larissa Pena, well, you've seen and heard from Larissa, Judicial Counsel of the Caribbean Court of Justice, to Paul Acqui, who you have not seen, but without whom this presentation that I hope that you have enjoyed, and I hope that has provoked you and challenged you, without Paul's expert assistance and guidance and knowledge would not have been possible. And last and certainly not least, to Candace Simmons, who is my own executive assistant, judicial, attached to the Caribbean Court of Justice, who, to be very honest, without whom very little that I do, I can do. She is not seen, but I can only say that without Candace, a lot of what you are enjoying, a lot of what I have the opportunity of doing would not be possible. So those are my acknowledgements. That's my gratitude. Larissa, thank you very, very much.
Thank you, Judge.
For being a part of this.
Thank you, Judge.
And to all of you, we wish you a good day. We hope that what we've said has been impactful, and we hope you will take steps now to make a difference. This is a call to action, a call to eradicate all contemporary forms of modern slavery and forced labor. It is a call that we as judicial officers constitutionally have to respond to. I wish you all a good day and thank you very much.